Now, Section 27 has launched a court application for access to free health care for all pregnant and lactating women and children under the age of 6 in Gauteng. The organization says they're asking the court to find that relevant Gauteng legislation and regulations are unlawful to the extent that they fail to provide access to free health services. For more, Head of Health Rights Programme at Section 27, Sasha Stevenson, joins me now. Very good morning to you, Sasha. Thank you for your time. You've launched an application. Talk to us about what prompted this move.
What we know is that the law is actually quite clear when it comes to access to free healthcare services for pregnant and lactating women and children under the age of 6. It doesn't provide for any limitations. But what's happened in Gauteng in the last few years is that regulations have been passed that require payment for those services for some people. And those people are primarily women who are asylum seekers or undocumented. And that's contrary to the national requirement that says that all such people who are pregnant, lactating or under the age of 6 should be provided with access to free healthcare services. And the reason this is so important is that healthcare services during pregnancy are needed to ensure that a woman is safe, that she's able to carry her pregnancy to term, that her fetus is safe, and indeed for young children, it's really important that they are able to access the healthcare services that they need. We've seen real gains in decreasing maternal and child mortality in South Africa, and we cannot be restricting access to services on the basis of citizenship when it's very clear in our national law that those services should be provided to everybody.
So what, in essence, forms the basis of your application? Are you saying that foreign nationals are deliberately denied access to free health care?
Yes, the provisions from Gauteng require payment for all asylum seekers and undocumented people, regardless of whether they are pregnant or lactating or under the age of 6. And the fees that are being charged are significant. It's really from 5,000 Rand. And so that's really the problem, is that there's this fee schedule that's being charged. And the problem is that where there are these provisions in the law and where there is some uncertainty, and there has been uncertainty in Gauteng in this regard for some time, it allows people to be turned away. And so it's important that we get clarity on this from the court, so that people are able to access the healthcare services that they need and, in fact, that they are legally entitled to.
You've also argued that Section 4 of the National Health Act needs to perhaps be relooked at because of its limiting conditions.
Section 4 of the National Health Act is actually quite clear. It says that the state and clinics and community health centres funded by the state must provide free healthcare services. So there's to these categories of persons. So there's nothing wrong with that provision. What's wrong is the way that it's being it's being changed by Gauteng and the way that the Gauteng regulations have been laid out and are being implemented. So that's what we're challenging.
So what do you think perhaps could be the reason that foreign nationals, undocumented migrants are being charged as opposed to South Africans? Are you saying that South Africans are not charged for the same services that the foreign nationals or undocumented migrants may be accessing?
We have heard some anecdotal evidence that some women who are South African also struggle to access services. But the evidence that we've received, and this has been over a number of years, has related to women who are undocumented or who are asylum seekers. And so that's really the group of women that seem to be particularly targeted in Gauteng. And as I've said, it's important that we change that, both in the interest of the health of the people involved, and also because when you don't provide services in a timeous fashion, the health needs become emergency health needs. And those do need to be provided immediately by health facilities. And so really we're shooting ourselves in the foot if we think that we should be excluding some women, pregnant women and children, from accessing timeous healthcare services, because then they become emergency cases that we need to deal with in any case.
So is the scope of your research exclusive to what you've observed in Gauteng, or perhaps could this be a national problem?
As far as we know, the problem is in Gauteng. And the problem really stems from these regulations that provide for the requirement of payment before services can be provided. So we don't know really what's happening in the rest of the country, but our understanding is that primarily the problem is in Gauteng. You'll also remember that for a number of years, there have been occasional circulars that get posted on the walls of Gauteng hospitals, limiting the rights of access to services to migrants. And in each case, those circulars have been taken down. The difference now is that the limitation has been brought into regulation, and those regulations are now being implemented, and that's what we're challenging.
Why the limitation? I mean, what could it perhaps be indicating, especially as we consider the climate that we're in with the ZEP conversation on one end, the stories around so-called xenophobic movements, the Operation Dudula. Do you think that it perhaps all speaks to the same tune?
I wouldn't want to speculate as to the motives of the Gauteng Department of Health in promulgating these regulations. What we are arguing is that the regulations themselves are unlawful and that they don't comply either with the National Health Act or with the constitutional right that gives everyone the right of access to healthcare services, and specifically and importantly references reproductive healthcare services. So I don't know why Gauteng has decided to take this approach. We haven't seen any response from them as yet to the litigation. The litigation is still new, and I'm sure we'll see their response shortly. But the point really is that the provisions of Gauteng are contrary to the Constitution and to the National Health Act, and it's on that basis that they're being challenged.
So in terms of timelines, when are you hoping to get some sort of response and take this matter forward?
We should be receiving a response in the next couple of weeks from the department. That's the time period that's provided. And so we'll know what the department intends to say in response to our application then. And depending on what they say, the legal process then moves forward as normal.
Thank you so much. Perhaps let's leave it there for now. Sasha Stevenson, Head of Health Rights Programme at Section27, saying that the organization is launching a court application for access to healthcare, specifically saying that persons seeking asylum, undocumented persons, and persons affected by statelessness are being told to pay for the services at hospitals in Gauteng.